Welcome back to Court TV Live. I'm Julia Janae in for Ted Rollins. This morning, we are following that breaking news out of Dedham, Massachusetts. Deadlocked for the second time. That's what the jury is telling the court in the case against Karen Reed. We've paused the deliberation clock, 22 hours and 36 minutes. It's day 5 of deliberation, and we are here watching that ceiling fan, waiting for movement from the court because we know the judge is going to bring in the jury to talk to them again. Still with us here in studio, Julie Grant sticking around, Court TV anchor. And Julie, you were just telling the viewers before the break about why what the judge is going to say now is different from what she told them on Friday. Because on Friday, she basically said, we know you've been working hard. Take a lunch break, clear your head, and keep working. Very short, to the point. And now she's going to say something very different.
Exactly, Julia. So it was too soon for the dynamite charge, right? You've seen it. We've seen it here on Court TV in many jurisdictions. That's known as the Allen charge. That was the case on point. And many jurisdictions refer to it as such. In Massachusetts, as you know, Julia, it's Tuey-Rodriguez. And so the dynamite charge is meant to spark unanimity in that jury room, because we want the jury to reach a unanimous decision. That is the goal in every criminal trial, the way our system's set up. And when there is deadlocking, as indicated on Friday, it was so early, as the judge said, look, you haven't been out that long. Now it's day 5. Now we're over the 22-hour mark, well over it. Now it's time to say, okay, reconsider your own position and think about the positions of your fellow jurors. So essentially, it's a charge of open-mindedness, of self-reflection, of considering rather all of the circumstances, because the judge will hear her remind them, you are in the best position to come to a unanimous decision, not anybody else.
You're the best jury, and you've been doing a great job, is what we usually hear from the judge.
You're right.
And there's that line, right? Because the court can't go so far as to force this jury. So that's why there are these limitations to make sure that the judge only reads and says certain things during this all-important moment where a jury is saying we just can't do it. You can't put them in the room and force them, because it would be prejudicial, right? If you're in this room, you can't leave, and you have to come to a verdict. There's going to be people making decisions that aren't within what our standards are, what the legal standards are for deliberation.
The idea is to consider everything. Make sure you're considering all of the viewpoints of your fellow jurors, considering your own, and then also being mindful of your own intelligence, the evidence in front of you, and knowing that other people from the community, just like yourselves, members of the jury, will have to be picked if we have to retry this. And one thing they won't learn is the expense. They're not going to hear anything from the judge about how expensive it would be to do this whole thing all over again. That will not be discussed. But what will be discussed is the fact that they are in the best position to come to a finding here, Julia.
That's important. And what we were just showing you was a look outside of that courthouse there in Norfolk County, Virginia. All of the parties have already come inside. We understand they may be waiting for someone. But the last thing that we heard is that the judge was going to bring in the jury. I am a bit surprised that the jury wasn't easier to get into the courtroom. It's been about 5 to 10 minutes now. Let's bring in our guest who's standing by to discuss this more. Josh Schiffer joining us from Atlanta, Georgia, criminal defense attorney. Josh, you've been analyzing this case from the very beginning. I want to get your take on whether it's strange to you or concerning that the jury only asked one substantive question about evidence. I mean, we see in some of these really big cases questions about everything. They want readbacks of testimony. They want to look at different evidence closer, even if they thought they wouldn't get it, even asking the judge to talk more about the jury instructions and perhaps the law. We only heard one request for a search report. The judge said you have all of the evidence, and we haven't heard anything else of substance on the case from them.
It leads me to believe that they were absolutely certain and confident with the evidence that they had, and the disagreement isn't based on some misinterpretation or anything like that. It's hard, obviously, to predict what's going on inside such an opaque room, but what it appears to be from my position is that there's a very firm divide on the vote, and that vote didn't move when the judge came out and spoke last week. Whether the judge or whether the jury moves now that they're going to hear this variation of the dynamite charge, just like Julie called first thing this morning, that's going to be really the end game. Either they go back there and make the decision, hey, everybody, we need to get together, or it's going to be a full and final hanging of the jury. They aren't going to be able to come back with a unanimous verdict, and that leaves the judge with very little options.
Yeah, Julie, let's talk about that case, because we talked about the ruling, we talked about kind of how this will play out, but in your experience, have you seen a change for jurors after the dynamite charge, after the judge actually goes through the way it's worded? Every state can be different as far as how they word their version of the Allen charge, but how often do you see a change? Or do they typically come back still and say, yeah, we still can't reach a unanimous verdict?
I've seen it. I've seen both. I mean, you know, so as far as cases on court TV, we've had this circumstance before. We have had it. I'd have to look back at the exact cases, but I want to say there was a California case where we saw the dynamite charge given by the judge. So it does happen. And the idea is that there will be unanimity reached. And another important point to clarify here is that we know that there can be a mixed verdict. You know, there can be, there's a lot of ways this can go, right? It's not, the jury has options here, is what I want to say. The jury has options. It's not only one charge.
Verdict slip.
Right.
We've got multiple charges and then lesser included, so.
Exactly, Julia. There's a lot.
They could split the baby, as we say it. If everyone is split on just not guilty versus guilty of something, then they could come to a lesser included charge to perhaps get those who are on one side to the other side. But sometimes if you feel firmly about someone being not guilty, it's going to be very hard to move them to the other side. Josh, your thought on that? If we learn the split inside of this jury room, the court no doubt will know if they ask how many are on one side or the other. Julie mentioned it this morning on opening statements that the judge would likely bring in the foreperson to see what is going on inside of the room, perhaps the numbers, perhaps what could help, and if there are any problems, but they can't go too far with that. But if there's a mistrial, the judge declares a mistrial, how important is that split to what happens next?
Well, the split's really important because of how the litigants and the stakeholders are going to interpret how they put their case together, what portions of the defense landed the way that they wanted. And there's always an opportunity to poll and speak with a jury after they've been discharged of their duties. What I think y'all are talking about right now is something we hammer all the time in criminal defense. There are two fears of jurors. Jurors are afraid of wrongful conviction, and jurors are afraid of wrongful acquittal. That's really the driving force. And when you look at a intractable jury,
Josh, I'm going to ask you to pause. We have movement inside of the courtroom, so we are going to go in and listen to the judge.
Court is in session. Please be seated.
All right, so jurors, I am in receipt of your note. Judge Cannone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please. Jurors, follow me.
You are muted.
Just looking there at John O'Keefe's family, you can only imagine what this must feel like. The weight of coming in and out of this courtroom every day, hoping that the end is going to be, in the least, a resolution, and it's looking more and more like we won't get a resolution in this case. Court TV anchor Julie Grant is still with us. Criminal defense attorney Josh Schiffer also standing by. Julie, that letter from the jury, it was deep, it was thorough. They are expressing in the most heartfelt way they can to this judge that they just can't reach a decision. I heard the word fundamental differences. What are you thinking when you hear this jury saying we're fundamentally on different sides?
Julia, I think they are pouring their hearts and their minds into these deliberations, and that they are doing everything they can to diligently work through the evidence, but they're conflicted. Internally, they are conflicted. It is very clear. I heard sadness, you know, when I heard the words "we're deeply divided," because we can tell these are people who have taken their oath very seriously to do this job that is of utmost importance to our criminal justice system, the job you take when you agree to serve on a jury. And you hear them saying, we're trying, we just can't. But, you know, we know, considering the length of the trial, considering the number of witnesses, I mean, Julia, you know, we've got 74 witnesses they heard from, 675 exhibits to go through. This isn't that long. The judge is right to give this instruction and say, keep going, keep working. You're in a position to do this job. Just like you heard her say, any other person, you know, would have to be big. Nobody's as intelligent, competent, equipped as all of you are, members of this jury.
Yeah, she gave them kudos outside of their presence, but she was telling the other lawyers, this is one of the greatest juries that I've seen in the way that they have been acting. Josh, I want to get your thoughts on it, but let's listen back to that moment. Just this letter that was read inside of open court by the judge, coming straight from the jury.
All right, so jurors, I am in receipt of your note. Judge Cannone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps
All right, we just wanted to hear that part, the letter from this jury. Josh, when you're hearing things like deeply held convictions, I mean, it sounds like they likely spent some of Friday and all of this morning writing that letter, crafting it to sound as convincing as possible to this judge to just let them go.
It is one of the most powerfully written jury messages I've ever read, and clearly they spent a lot of time choosing the right words, respecting the process deeply, respecting all the other jurors involved, and taking a very high road, which is great. It's fantastic. It shows the seriousness of this jury and what they've gone through. On top of the sadness that Julie notes, I am also feeling there's some frustration there, because they have put in all of this work over weeks and weeks, 74 witnesses, all of this effort, and now they're frustrated that they can't complete their duty. And I don't hold out a lot, because it feels to me that there's an ideological divide that's never going to be jumped with these particular 12 jurors. It seems to me that there are people who believe they cannot leave without a conviction and cannot leave without an acquittal. And that's unfortunate.
When you have a fundamental difference like that, it is a tough decision. We're talking politics, religion level, it sounds like, coming out of that courtroom.